All right, welcome to The Explainer. Today, we're jumping into one of the absolute cornerstones of property law, registered land. We're going to break down the Land Registration Act 2002 and really get to grips with its main goal, which was to create this perfect mirror reflecting every single right on a piece of land. But, and this is the big but, as you'll soon find out, that mirror has a pretty famous crack in it. Okay, so here's how we're going to tackle this. First, we'll look at why the system was created, that whole mirror principle. Then, the priority rules that are the engine of the whole thing. We'll cover what actually goes on the register before diving into the really juicy part, that crack in the mirror, or what we call overriding interests. And finally, we'll wrap up with how other types of interests get protected. Let's get into it. All right, first up, the goal. Why was the Land Registration Act 2002 even created? Well, you have to imagine what it was like before. Buying land, it was a total mess. You'd be wading through stacks of dusty, old, complicated documents. It was a nightmare. The LRA was designed to just sweep all that chaos away and bring in some much-needed clarity and certainty. So yeah, the old system, you had to trace something called a good route of title through this mountain of deeds. And let me tell you, it was slow, it was super expensive, and honestly, pretty uncertain. The LRA 2002 came along with this, well, pretty radical idea at the time. Let's ditch the pile of paper and create one single official register. The big idea here is that this register is supposed to act like a perfect mirror. It should reflect everything, all the rights, all the burdens on that property, so a buyer can just look at this one document and see the whole picture. Simple, right? Okay, Section 2, the two priority rules. Now we're getting into the real engine room of the Act. This is the stuff that decides who is bound by what when a property changes hands. Honestly, if you want to understand registered land, you have to get these rules down. And this distinction you see here is absolutely critical, especially for any problem question you're going to face. You've got two main rules. First, there's Section 28. That's the basic one. Think of it this way. If you get the land for free, like a gift or an inheritance, you're stuck with all the existing rights on it, no special treatment. But then there's Section 29, the special rule. This is a massive deal for people who actually buy the land. If you're a purchaser for valuable consideration, you get this amazing protection. You can actually take the property free and clear of certain interests that haven't been properly protected. Section 3. What's on the register? So we've talked about this perfect mirror. The logical next question is, what exactly is supposed to be on it? What are the big ticket items that have to be registered to count? Well, these are the heavy hitters, what the Act calls registrable dispositions under Section 27. We're talking about things like freeholds, long leases, legal mortgages, the really major stuff. And the rule here is dead simple. To have full legal force, they must be on the register. If you don't register them, they don't just disappear, but they drop down to being equitable interests, which is a much weaker position. And the case of Sainsbury's versus Olympia Homes is the perfect cautionary tale. A failure to register meant the legal title didn't actually transfer. Imagine that. It shows just how high the stakes are. Okay, but wait a minute. What about the kind of interests that you're not supposed to see on the register? I'm thinking about stuff like, a family member's financial contribution to the house, which gives them a beneficial interest under a trust. These are precisely the kind of hidden rights that could pop up and bite a purchaser as an overriding interest. So to handle this, the law has a really clever trick up its sleeve, and it's called overreaching. And here's how it works. This process was famously laid out in City of London Building Society v. Flegg. It's actually designed to protect everyone involved. If a buyer pays the purchase money to at least 2 trustees, that's the magic number, they overreach that beneficial interest. Now, the interest doesn't just vanish into thin air. Instead, it kind of lifts off the land itself and reattaches to the money that was just paid. So the beneficiary still has their financial stake, it's just in cash form now, not in bricks and mortar. And for the buyer, they get a clean title. It's an absolutely essential mechanism for keeping the whole process of buying a house straightforward. So, to recap, overreaching is this fantastic tool for clearing those family-type beneficial interests off the title, making sure they don't cause problems for a buyer. But what happens when an interest can't be overreached, and it's also not on the register? Well, now we've arrived. This is the big one, the most debated, the most litigated, and definitely the most examined part of registered land law. We're talking about the famous crack in the mirror, interests that override. These are the ghosts in the machine, rights that can bind a buyer even when there's absolutely no trace of them on the register. So what are they? Essentially, these are rights that the law considers so important that they deserve protection even without being formally registered. Now, the 2002 Act did try to trim them down, but the big one, the one you absolutely need to know, is the interest of a person who is in actual occupation of the land. You'll find it in Schedule 3, Paragraph 2 of the Act. Now, for someone to successfully claim this kind of overriding interest, they have to jump through a few hoops. It's not automatic. First, they need to have a proper property right in the first place, like that beneficial interest we talked about. Second, and this is key, they have to be in actual occupation at the time the property is sold. And third, there are some checks and balances. Their occupation has to be discoverable, or they can't have hidden their right if someone asks them about it. So let's really zero in on that crucial phrase. What on earth does actual occupation mean? Well, the classic place to start is with the House of Lords case, Williams and Glyn's Bank versus Boland. And Lord Wilberforce came up with this really straightforward factual test. He basically said, and I'm quoting here, "What is required is physical presence on land." In other words, it means exactly what it sounds like. It's about actually physically being there, not some fancy legal definition. But, in law, it's never that simple, is it? Later cases added some important details. In Abbey National versus Cann, for instance, the court said just moving some furniture in 35 minutes before the deal closes isn't going to cut it. Occupation needs, and this is the key phrase, some degree of permanence and continuity. But then you have a case like Lloyd's Bank versus Rossett, which shows the other side of the coin. There, the court decided that having builders on site every day during a major renovation could actually count as occupation, even if the person themselves hadn't moved in yet. So that leads to a really interesting question. What if you're temporarily away? What if you're not physically in the house on the exact day it's sold? Well, the courts have been surprisingly flexible here. Take the case of Chokar v. Chokar. A wife was in the hospital, literally giving birth, when the sale went through. The court said her occupation hadn't been broken. Why? Because all her stuff was still there, and she clearly intended to come back. And even more dramatically, look at Link Lending versus Bustard. A woman had been sectioned in a mental health facility for over a year, but because she always saw the property as her home and intended to return, the court said she was still in actual occupation. It's pretty powerful stuff. Okay, but to balance things out, the 2002 Act threw in a really important protection for buyers. An interest won't override if the person's occupation wasn't obvious on a reasonably careful inspection. The case of Thomas v. Clydesdale Bank really helped clarify this. It means there have to be visible, physical signs that someone's living there. And here's the crucial bit. The buyer doesn't need to have figured out the person's legal interest. They just needed to be able to see the signs of their occupation. It's a check on completely undiscoverable rights. Right, on to our final section, protecting other interests. So we've covered the big registered rights and the invisible overriding ones. But what about all the other stuff? Things like restrictive covenants or contracts to buy the land. How do those get protected? Well, the system gives us two main tools for this: notices and restrictions. And it's really important you don't mix these two up. Think of a notice under Section 32 as a big red flag on the register. It basically shouts to any potential buyer, hey, this other right exists, like a restrictive covenant, and it makes sure the buyer is bound by it. A restriction, on the other hand, is more like a pair of handcuffs on the current owner. It actually limits their power to sell or mortgage the property. A classic example is a restriction that says you can't sell this house unless the money is paid to two trustees, which, as we now know, is there to make sure overreaching happens properly. And that really brings us full circle. The whole point of the Land Registration Act 2002 was to create this perfect mirror, right? A system where a buyer could just look at the register and know everything. But by choosing to keep overriding interests, the law deliberately left a crack in that mirror. And this leaves us with a big, central question that people are still debating today. Is that crack a necessary protection for vulnerable people who are living in a property but aren't on the paperwork? Or is it a fundamental flaw that just undermines the very certainty the whole system was trying to achieve in the first place?